protects freedom of expression, sometimes called freedom of speech. The definition of what is protected as expression under Section 2B of the Charter is quite broad and includes more than just speech. From Irwin-Toy v. Quebec, an important Supreme Court case from 1989, we know that expression has both a content and a form. Content is the meaning that is being portrayed. Form is how that meaning is being portrayed. Form can be verbal, in written word, in music, or physical gestures. For example, I wear a rainbow pin on my jacket. Wearing this accessory is my chosen form of expression. The meaning or content I wish to convey when I wear this pin is that I support LGBTQ+ rights. In the Irwin-Toy case, the Supreme Court also identified the values underlying freedom of expression. Not only is freedom of expression important for each individual's own self-fulfillment, it also facilitates our pursuit of truth as a society and enables political discourse, that is, conversation and communication about laws and government behavior. Each of these values is essential to democracy. While many activities count as expressive, some kinds of expression don't end up protected under Section 2B of the Charter. Most often, issues about whether or not a certain type of expression should have Charter protection are settled in the courts, where an analysis is done to determine if a limit on freedom of expression can be reasonable and justified under Section 1 of the Charter. One example of expression that is not protected by the Charter is threats of violence, or conveying meaning through a violent act. Sometimes, expression in certain locations might also be excluded from Charter protection if it conflicts significantly with the values of freedom of expression. For example, staging a protest inside a cabinet meeting could interfere with the way our government functions to such a degree that it prevents important political discourse from taking place, even though that same protest would likely be protected outside the Parliament building. You might be wondering, what about hate speech? Is it protected under freedom of expression? This is a tricky question and a controversial topic in Canada. It presents a difficult dilemma because the answer depends on how you define hate speech. If we define hate speech too generally, then we could be in danger of silencing opinions that might be valuable to consider in a free and democratic society. For example, say you feel passionately opposed to a zoo that has been known to be cruel to animals, and you state publicly how much you hate the owner for profiting from this mistreatment. Should there be a law that prevents you from expressing these feelings? Could sharing this information benefit the public? On the other hand, if we have no protections against hateful speech, we could be exposing some individuals and vulnerable groups to real harm and discrimination. Certain types of expression can potentially dehumanize a group or encourage others to have extremely negative feelings towards members of that group. Should we have laws to protect people from these types of harms? The most recent Supreme Court case on this issue is Saskatchewan Human Rights Commission versus Woodcutt from 2013. Mr. Woodcutt distributed flyers containing language that the Saskatchewan Human Rights Commission claimed promoted hatred against homosexuals. Mr. Woodcutt argued that the flyers should be protected under Section 2B of the Charter as expression. The case made its way to the Supreme Court of Canada, where the court determined that the provincial rules against hate speech did limit Mr. Woodcutt's freedom of expression. However, the court also found that those limits were reasonable and justifiable within the meaning of Section 1 of the Charter. In the court's analysis, the provincial government's rules against hate speech carefully and proportionally tried to meet an important objective, reducing discrimination and furthering equality and human dignity. The court also tried to minimize the restriction on freedom of expression by interpreting hate speech as referring to only the most extreme forms of speech that are objectively seen to expose protected groups to hatred. Despite being a form of expression, the court characterized this type of hate speech as far from the type of expression that reinforces the core values underlying freedom of expression. Rather than support self-fulfillment, hate speech seeks to undermine the self-fulfillment of some people simply based on their identity. Not everyone agrees with the Supreme Court's decision in Woodcutt. Some people argue it is safer and healthier to know who is perpetuating hate speech and how they are doing it, and to be able to make strategic choices about when and how to respond to hate speech.